Hello and welcome to McKenzie Friend. Today we're going to look at abiding by parenting orders in the presence of the COVID-19 crisis. The first usual disclaimer: whilst I hold a law degree majoring in family law, I choose not to practice nor seek commission. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Right, let's look at public health orders. Since I'm from New South Wales, my law degree is from New South Wales, I tend to prefer discussing New South Wales law. Now, New South Wales has issued a public health order. This is under the Public Health COVID-19 Restrictions on Gathering and Movement Order 2020, and this is under the Public Health Act 2010. This restrains a person leaving home without a reasonable excuse. Reasonable excuse includes continuing existing arrangements for access to and contact between parents and children, or children who do not live in the same household as their parents or one of their parents. I put the link below. There's also been some statements from the Chief Justice of the Family Court, Chief Judge of the Federal Circuit Court, His Honour William Alstregren. Now, there's the interview below and also the statement from the court. Now, reading through the statement, His Honour notes, it is imperative that parents and carers act in the best interest of their children. This includes ensuring their children's safety and well-being. Also, courts make orders that are determined to be in the best interest of a child. Caring for and determining the practical day-to-day best interest of the child is primarily the responsibility of parents and carers. Consistent with their responsibilities to act in the children's best interests, parents and carers are expected to comply with court orders in relation to parenting arrangements. This includes facilitating time being spent by the children with the other parent or carer pursuant to parenting orders. Now, he also stated, in the highly unusual circumstances now faced by Australian parents and carers, there may be situations that arise that make strict compliance with current court orders very difficult, if not impossible. This might occur about the ban being able to go between states. However, there remains a duty to comply with intention of orders, and parents should communicate and reach practical solutions that both ensures the health and safety of the children and substantial compliance with the orders. Now, note the word substantial compliance with the orders. At all times, parents or carers must act reasonably. To act reasonably or to have a reasonable excuse for not complying with court orders is a matter that is considered by the court, pursuant to Section 70 NAE of the Family Law Act. Now, looking at some legal commentary, Legal Aid New South Wales Family Law Director Kylie Beckhouse stated, people will still need to comply with court orders. These are really stressful, unusual times, and children are under enormous stress, and the best thing people would do right now is keep things conflict-free as possible. Family lawyer Rebecca Bunny stated, it is possible that people might use this opportunistically to deprive the other parent of time with their children. This is a public health emergency. This is not an excuse to start messing around with your parenting orders just because that is what you want to do. It's not about cutting that other parent out. It's about keeping everyone safe. Ms. Bunny also went on to say that I would be recommending to people is to put everything in an email, have everything in writing, set out your concerns really clearly, and do your very best to have a sensible, practical discussion about this. If the matter then came before the court, you will need to be able to show what you were thinking at the time and that you did your very best to communicate that to the other parent. Now, going back to His Honour, if an agreement can be reached about new parenting arrangements, even if they are to be adjusted for a short period of time, this agreement should ideally be in writing, even if by way of email, text message, or WhatsApp between each other. This will be particularly important if there are later family law hearings and will assist all concerned, including the court, to understand what agreement may have been reached. Now, the court's also made some other directions, and it's talked a little bit about the difference between physical distancing and social distancing. So what they're saying is, even if physical distancing is difficult, if not impossible, that does not preclude social distancing. So the court is suggesting that the defence of reasonable excuse for failing to abide by parenting orders may be determined based on compliance with the spirit of the orders and what alternative measures were undertaken by the withholding parent to ensure the child has contact with the other parent, even if that does not involve physical contact. So looking at some alternative contact, increased level of non-personal contact through FaceTime, Zoom, etc. Maintain the same amount of time with each parent through larger blocks of contact and reduced number of handovers. Agreements on ensuring social distancing and contingency should a child or parent become ill. Now, looking at dispute resolution options for parents who are having difficulty, Family Relationships Advice Line can be contacted on 1800 050 321 or visit the website. Resolution with the assistance for lawyers in the interpretation of orders, shuttle negotiations between parents, or drafting temporary orders. Electronic mediation services are available from the courts and through the local bar associations and law societies during these restricted times. So you can visit their websites for information on that. Now, looking at the involvement of the court. The law requires separated parents who have a dispute about children to make a genuine effort to try and sort it out through family dispute resolution before filing an application for parenting orders in court. It is expected that this crisis will delay current matters before the court and increase parent disputes, such that it is important that parents in dispute should make all reasonable efforts to resolve issues without the intervention of the court. So in the conclusion, at times of crisis, it is important to try and remain civil and be reasonable and practical in seeking to resolve any issues. There are support services available to assist parents in dispute. And everybody try and remain calm and not further escalate the acrimony, and look for solutions to allow the child to continue to have contact with the other parent. I hope this helps.